Welcome to We Are the People. This is Jacob Milton. Like every other day, sometimes we try to bring a subject which concerns 180 million Bangladeshi people at home and in abroad. Audience, Bangladesh nowadays is going through a severe situation politically, economically, internationally, and in some other aspect, but some of the issues become really vital to our country's existence. One of the subjects become really crucial for the last couple of months. That subject was Zia Orphanage Trust. That in that case, so-called government prosecutor are accusing the former Prime Minister, Begum Khaleda Zia, and her government to steal money from that Zia Orphanage Trust. On the other hand, I'd like to discuss something in regards to the removal of the Chief Justice of the country named Surendra Kumar Sinha. So usually this is the subject in Bangladesh. Bangladesh judicial system kind of copies of British judicial system. American judicial system is a little bit different, but law is a law. Some of the case and some of the atmosphere of the case is almost similar, whether it is a British law or whether it is American law. Today, I'm lucky to have two of the prominent attorneys, those who are practicing law in America. One of them was a government prosecutor in the past and right now in private practice, and another attorney who is with me was a former diplomat. Right now, he's also in a private practice. Ladies and gentlemen, let's meet one of the guests who was a government prosecutor in the past and right now he is in private practice. He is no other than the well-wishers of Bangladeshi community, Mr. David Korngold. Mr. Korngold, welcome to the show, sir.
Such a pleasure.
And audience, I have another well-wisher of the Bangladeshi community. He's a former diplomat, also an practicing attorney. His name is Mr. Octavian Marian Florescu. Mr. Florescu, welcome to the show, sir.
Pleasure to meet you.
David, let's talk about a grand larceny case.
Okay.
In a grand larceny case, in a criminal case, some entity or some individual has to lose more than $10,000. Then it's become a grand larceny.
In general,
is it, in general, is this the description of a grand larceny?
in general, they also have to have intent to deprive the person of the money.
A person of the money. Here is the case. In 1991, the time Begum Khaleda Zia was the Prime Minister of Bangladesh, at that time, Emir of Kuwait donated about 178,000 or 200,000 US dollar or 250,000 US dollar to a charitable organization called Zia Orphanage Trust. The Zia is the former president of Bangladesh, husband of Begum Khaleda Zia. Now, they put total of say about 300,000 US dollar. And at that time, Begum Zia was the Prime Minister of Bangladesh. They says, okay, we got the money and we are going to build one, it's called Orphanage House after her husband's name, Zia Orphanage House or whatever organization they're going to call it. What happened, they make the plan, they ask the architect to come up with the plan, but total costing comes out close to $15 or $20 million. But in hand, they had only $200,000, $300,000. So I believe Begum Zia and her government says, do you know what? We need to raise more money to start working. So just put it in a bank and we'll go from there. When all those monies will come, we'll work with this. They open up a bank account and they deposit that money, came from other country as a donation. By the way, when they open up the account, Begum Zia did not even put her signature. It was just name of the office of the president or office of the prime minister. Without her signature, her chief of staff or her staff opened up the account and the money was sitting down there. Suddenly out of nowhere, this government this illegal government of Hasina Sheikh comes up and says she tried to steal those money. Now, that money came from another country as a donation sitting down at the bank account where Mrs. Zia's signature was not even involved with the bank account. She did not withdraw a single penny out of that account. All the monies are there. She disclosed it. Every year's her tax return and everything, that money is there. He disclosed it to the government that, guys, money is there, still we didn't have enough money to build up that orphanage house. But out of nowhere, just to disqualify from the election or disqualify her as a political leader, suddenly they issued an arrest warrant and says, okay, we have to try this case. In this case, they call witness after witness. But I'm giving you an example. Khaleda Zia became the Prime Minister of Bangladesh for the first time in September 1991. But by mistake, government, they falsified the evidence. That shows she opened up the account in March 1991 while she was not even the Prime Minister, did not even get the money. There's lots of important issues within these criminal cases, that who said it, where you find it, where that money lost, how this money lost, there is no answer. But there is a case. In this case, Begum Zia took a stand. At that stand, she described everything. That, listen, she looked at the judge and says, money is there. There was a $200,000 or $300,000. Right now, that $300,000 becomes $600,000 due to the bank's interest. My signature even not there. I disclosed it to the government that money is there because we didn't have enough money to build the structure. Still, at the end of the day, they convicted her of grand larceny and intent to deprive orphans. Now, they classified it as a grand larceny. You are a government prosecutor. You know how grand larceny works. Can you describe under these circumstances, as a prosecutor, how do you convict a person whose signature was not there, did not even lost a single penny, and who disclosed everything to the government?
Well, if you analyze it from a perspective of American legal system, it's very clear that that doesn't qualify as a grand larceny. First and foremost, a grand larceny requires at the minimum three things. One is the intent to deprive. You have to prove that. So, for example, if somebody borrows money, intends to pay it back, even if that person borrows it under fraudulent purposes, it's not a grand larceny. There's no, you cannot prosecute somebody for grand larceny under those circumstances. So, similarly, in this case, I haven't heard a shred of evidence that shows that even if the money is not there for whatever reason, that it was taken with an intent to deprive.
Yep.
Okay. But let's go into the meat of the case, okay? Let's assume that we can, let's pretend, even though obviously they haven't, let's pretend that the government's case demonstrated that, or let's put that aside for a second. Well, a grand larceny, you have to show, of course, three things. One is that the accused person actually took the money. I haven't heard any evidence that she has possession of the money. If you don't have possession of the money, you didn't take it. So it makes no sense.
That money being lost, no.
Right. Second of all, you specifically described an account that's not in her name. So she doesn't have access to the money per se, only the office of the Prime Minister. So unless the bank colluded with her to allow her to steal the money, which means that the bank itself should have been on trial, there's no way she personally took the money. How would the bank release money to a private individual when the account is not in that individual's name? So unless the bank itself was prosecuted, which clearly not in this case, so this is clearly a political witch hunt. There's no other explanation for it because it's the bank that's at fault, not her. If somebody has, if somebody's not on the account, yet money was released to them anyway, then clearly that's a bank fraud. That's not something that that person is personally liable for. So for those obvious reasons, this is not a grand larceny under American law certainly in a court of law, this case A would never have been brought to trial here in the United States. B, you can't prove it. There's no proof from what you've told me. There's no proof that she intended to commit grand larceny with this money. Fourth of all, she's disclosing the money, the existence of the money. So it makes no sense to claim that she was the one who took it, because obviously someone who's disclosing the existence of the money allows the government to know that she has an account, even though it's not in her name, she has some sort of connection to that account. So it makes no sense that she would then proceed to take the money if she just explained to the government that she has some sort of connection to that account. So the whole thing is pretty preposterous.
Mr. Prosecute, that's the things. You already studied President Zia Rahman, one of the honest presidents of Bangladesh. And Begum Zia is the widow of President Zia Rahman. Begum Khaleda Zia was the 3-term Prime Minister of Bangladesh. Amir of Kuwait donated a little bit of money to build an orphanage home for orphans, and that orphanage name was supposed to be after the name of her late husband. Now, why you think the wife of a former president who happens to be a prime minister for 3 terms would steal money from a project, that project name after her late husband? Does that make any sense to you?
No, it doesn't. Indeed, I had the pleasure and the honor to present the life of General Zia Rahman.
Yep.
On the occasion of the Independence Day, the Victory Day,
yes,
most precisely. And I mentioned also his wife, who took in her hands the fate of the BMP after his death, and to lead, let's say, large masses.
Yep.
To achieve the goals of Zia Rahman. So to answer your question, I don't see any reason that she would use that fund bearing her beloved husband's name to just to steal money. As my colleague and my friend, Mr. Korngold, specified, and he made the point legally, there is no evidence to show up the larceny, the grand larceny that she's accused of. Although I saw that she was sentenced to 5 years in prison on February 8th.
Yep.
And when I read the articles, I was surprised by an assertion of the judge who read the 262 pages of the sentencing decision, saying...
As a matter of fact, that is 367 pages.
Or 367 pages, one per day, over 1 year. And he said that no one is above the law. This is a wonderful principle. You can find it in every modern constitution of every democratic country, but somehow, when I'm thinking about nowadays politics in Bangladesh, it seems that this phrase reads, nobody is above the law because Hasina Sheikh is the law.
Ah, that's wonderfully said.
I cannot make a trip in Khaleda Zia's mind. It will be impossible for me to check and to argue because I didn't see the trial. However, after all the events that unfold, I'm almost certain that she wanted to celebrate the memory of her husband and to cherish his memory by opening this orphanage.
Orphan homes, yep.
Besides the legal aspects, there are some moral aspects that she proved during 3 terms of being prime minister. She wasn't accused of anything, so it was a lapse of time during the 2 mandates. It would have been, let's say, time to start a trial if anything went wrong with the orphanage. However, the trial started in 2008. And I think that the actual Prime Minister, Hasina Sheikh, is playing by the book of the totalitarian regimes that I had the misfortune to know for 22 years, but I had the privilege to escape and to see both sides of the story. So she plays by the ABC of the totalitarian regime. In an electoral year, you decapitate the opposition and the famous leaders like Khaleda Zia, just to take control and manipulate the followers that are in great number and to perpetuate yourself into power. Yeah, I see no reason, moral reason, political reason, and as Mr. Korngold said, no legal reason and no legal evidence of intent to deprive the orphanage that bears her husband's name of any funds, and she made it clear that the funds are still there.
Yep.
And she never used it.
One thing I don't understand, you said there's something. Okay, that account was under the trust names called Zia Orphanage Trust. Begum Zia was not one of the even signatory. If that person is not even signatory on the account, how she can be accused of stealing money or intent to accuse money? Her name is not there, her signature is not there. How they would have steal that money? Like, can you explain to me? Is it doable? Like, how? Say my name is not on the account and my signature is not on the account, and I'm being accused that I tried to steal money from the account.
It sounds very odd. In order for the money to leave the account, as we know, banking rules, the bank must verify, especially a sum that large, the bank must verify the person who's removing the money from the account and the recipient. Those are international bank law. And these documents are available to the prosecution.
Yep.
There's no doubt that this would be Exhibit 1.
Yep.
Yet these documents were never produced at the trial.
No.
And therefore, as Mr. Floresco just explained, this has the hallmarks of what they call a kangaroo court. The evidence is not there. The rules of trial are not followed. And clearly, the verdict of guilt was a foregone conclusion. There's no doubt that this was a typical political witch hunt in order to deprive the opposition of their freedom. This is the kind of thing that Nelson Mandela went through for many years.
Yes.
The kind of things that people in Russia went through for many years. Other totalitarian regimes, people get locked up because the easiest way to control a country, aside from controlling the journalists, which is rule number 1, use the penal system to deprive enemies of the totalitarian regime of their freedom. This prevents them from fighting.
I have another question. When in the court, after the trial, when judge reached his decision and give his verdict that okay, he is guilty, what is the court? What is the protocol? Before judge give his verdict, he should write all of his decision, like based on what argument he's making that decision. This is the law. This is the protocol of British justice system and American justice system. Is there anything different, or just can say, no, I'm going to write the decision 10 days later, I'm going to give a verdict today?
Well, in general, in the American system, what happens is that if at the conclusion of trial, after all the evidence is presented, it's insufficient as a matter of law, the defense makes a motion to dismiss based on insufficient evidence. That motion must be ruled upon by the judge before the trial can continue.
Okay.
So, in general, the court does have an obligation if not in writing, at the very least, to speak from the bench the decision on the motion and why that decision is made. So if you're denying the motion, okay, you have to explain why you found the evidence sufficient. If there's no document that exists like that, again, that points to corruption.
On this case, Begum Zia got convicted on February 8th by the court. A single judge was running the trial. Okay. And then the procedure to file an appeal, they have to get the decision, a copy of the decision by the court.
Okay.
The attorneys for Begum Zia went to the court and asked for the transcript and for the decision. They says, we don't have that decision right now. Still have to write it, and still we have to prepare the decision. And then why it will take a decision without the judge's decision? How you send Begum Zia to the prison? Then they says, oh, it is a 635-page decision. And says, okay, we need the copy of the decision in order to file an appeal.
That's right.
They couldn't give the copy of that decision for a week. Is it normal, or this is?
It happens in some. I won't make a parallel with the American system. I can make a parallel with the civil law systems that exist in Europe. There is a possibility to postpone, to give a verdict on the spot at the end of the trial, and then to postpone for 30 days, not more, the publication of the decision with the motivation. However, it's a long decision. I wonder how many pages the whole file had, if 600 and something.
Since 635 pages.
Score of pages is the decision. I don't understand. Maybe he ruled on every page. Every
page or every word of the testimony?
It is possible. However, as Mr. Korngold said, there are specific phases, and there is a final phase, which is the sentencing, right? Usually they separate the sentencing phase from the trial, and the sentencing is read the full decision. I don't know what happened in this trial, and did the magistrate read the whole decision, or
no?
So he made a short ruling,
and they sent her to prison. My question is, if there is a 635-page verdict, okay, I understood. Probably he went through every single testimony of the witness, and then he justified his verdict. Now, question is, the way Mr. Florescu said it, why after the all testimony and trial, they could have recessed the court for a month that, okay, let me finalize the ruling. The way immigration court does. Okay, well, I didn't write the decision yet. I need a little bit more time, and I'm going to write the decision and then come back to the court after a month or after 2 weeks.
Just for the appeal to go forward?
Just to go for the appeal forward. Does that make any sense to hold the accused, send her to prison, and taking more time to write the decision? Does that make any sense to you?
Well, I've got to be honest. If there's no evidence in the trial, then
they have to fix the evidence.
Have to put the evidence into the
you have to postpone
page decision.
Okay.
You know, it's again, all these are hallmarks of an illegitimate trial and an illegitimate verdict. This is what is done to hamper justice in order to prevent somebody from fighting the decision, from utilizing the courts, from utilizing the civil procedure to allow themselves to prove their innocence. Of course, if somebody was given the right opportunities, they might very well be able to persuade a judge that they're innocent. So the regime must take away all opportunities to present their case. Otherwise, we're left with believing that there was a coincidence, that somehow we have no evidence, flagrant disregard of justice, and accidentally not having a decision in a timely manner which allows her to appeal, plus sending her to jail while the appeal is pending. All these things are the hallmarks of a
kangaroo court, corruption. Also, we have to bring in another issues. Finally, after a week or 10 days or 2 weeks later, finally when the court says, okay, we have that copy of the decision. Now, they mustered in the decision, like however I said, Begum Zia looked at the judge, says, you guys are accusing me that I committed crime? It's a question mark, like, I committed crime? You think I took money? Do you know what they did? With the court transcript, they removed the question mark and said it, I commit the crime, full stop. It means changing her testimony, whatever she says in the court, showing like she admitted her guilt. Whereas,
is this tampering with evidence? I think it's because this is they put it as evidence. A question that she asked to the judge and transform it into
an
sentence, into an admission, and put it forward as an evidence. I'll ask my colleague, Mr. Korngold, but it seems like if they forward it as evidence, this is fabricating evidence more than presenting evidence.
Also, you have to analyze the statement. If somebody says, I committed a crime, they didn't admit to committing any specific crime. If they didn't admit to committing any specific crime, in fact, they didn't actually admit to committing any crime. It's not an admission. It's just simply, under any circumstances, you can't say, well, I committed a crime means that I committed the crime that you're accusing me of. And so it's, again, and obviously this trial is replete with these things. There is no evidence here, but whether they change it or take out a question mark, all these things don't amount to anything. That's not an admission of guilt in this case. In addition, how many times has she denied committing the crime?
Hundreds of times.
So it makes no sense to try to couch a sentence that she was now admitting to the crime, when indeed she's clearly on the record as having denied the crime, and she didn't admit to any specific crime. So it's really a meaningless thing, but it's the kind of, I guess you would call a propaganda coup, where you make a big deal out of something that is irrelevant, but it sounds good, it plays well to the public, or at least they could hang their hat, so to speak, or point to something that she may or may not have said. Again, it's just propaganda. It's just the way.
I think it's more than propaganda. Propaganda, it is when, let's say, newspaper or the media are transforming a statement or a question into a statement. However, this is a sentence that was said during the trial, and it was transformed into evidence. It was fabricated evidence, maybe, because I didn't see how it unfolded. I say maybe. But this is showing maybe lack of evidence on other sides, just to cover, you know, the lack of evidence. They put an assertion and presented it as an evidence.
David, how does it sound? A judge of the court is making a verdict. Now, of course, judge signed on a after the decision, that 635-page decision. Now, how does it sound that all those stenographer or who typed it, they change the sentence in a different manner when Begum Khaleda Zia says, "You are accusing me of committing crime? Show me where is the crime." They instead says, "I committed crime." changing those things, then is there any legitimacy of that court or legitimacy of the judge or legitimacy of this entire judicial process?
Well, clearly not. Obviously, if they were here with us,
yeah,
right, they would never come on your show. We know that.
Yeah.
But they would be too afraid. But let's say, pretend they were here. Obviously, they would say, no, you're wrong. She didn't say it with a question. Of course, they would assert that they were, not fabricating. I'm sure they would. But the fact is that statement in and of itself is just an ambiguous statement. So there's no doubt that doesn't prove anything one way or the other. So it makes no sense to pretend that somehow that's evidentiary. Okay? You cannot use an excerpt of somebody's testimony, take it out of context, and then proclaim that was an admission. Where's the sentence before? Where's the sentence after?
Right.
This is common sense. No, in any argument, I don't take a word that you say. You one time said Tuesday, and then I claim, oh yeah, Jacob said Tuesday. That makes no sense.
Yeah. You put it in a context.
Yeah, you can't just take words. So where's the phrase before? Where's the phrase? Where's the paragraph? What is she saying it in response to? Is she asking a question in response to another question? Was she asked a question? So obviously, these things can easily be taken out of context. And right-thinking people who have good in their hearts, know that this is improper and would want to know what the rest of the paragraph is. Where did that sentence come from? Everybody would want to know that.
Also, I have another question. They're going to go to the bail pending hearing, I think, leave to appeal.
Okay.
What is it called?
It depends. In other words, we're holding now where she's been incarcerated pending appeal,
yeah,
and she wants to know if she can get bail pending appeal.
Yeah, okay. So now on that appeal, the way that copy of the verdict being presented, that she admitted these, don't you think defense counsel should have asked the court that this is one of the historical trial, there is an audio recording, should be at the court? What's your suggestion to the defense team while at the time of the bail pending hearing?
Well, if this is what they're relying on, this is like all the evidence that they're relying on, so it makes no sense that this would be sufficient to keep her in on bail. Because if you analyze it at the end of the day, breaking down all the things that we said, A, saying the words "I committed a crime" is not an admission of guilt of this particular crime. A. B, you have to put it in context. C, where's the audio recording? Or, this was not a closed trial where nobody else was there.
Everybody was there.
Everybody was there. So if there's 100 witnesses and you'll have 100 affidavits saying that she asked in the form of a question, so this is specific evidence. So even if there's no audio, which of course there would be no audio, and we already know how these things operate, even if there was audio, that particular audio phrase would have been garbled or missing or deleted accidentally. So we know what would happen. But it's irrelevant. The bottom line is that there were many people there, many people willing to testify. Plus, she herself has a persuasive argument. If a person says, you stated something in a manner that indicated you committed a crime, right? And they feel like we already discussed that you can't take it out of context, but let's put that aside for a second. The person that made that admission also, by definition, has the right to explain the alleged admission. So if somebody, for example, makes an admission to the police, right, in the United States, that admission would be placed into evidence as evidence of their guilt. That makes sense on many levels. Some levels it doesn't, but let's say that's the proper procedure. But of course, that person then has the corresponding right to testify regarding their admission and to explain what the context was, whether that was an admission. So it makes no sense for them to claim that she should not have a bail hearing or she should be denied bail on paper without having the opportunity to present her case. So this whole thing really doesn't make sense, and procedurally, I can't imagine that that's proper civil procedure. Not claiming to be an expert on Bangladeshi civil procedure, but this is standard throughout all the democratic societies in the world. These things have their roots in common law in England, and a person who is being convicted on the basis of an admission always has the ability to explain their admission.
I don't think it's proper to believe that she was convicted on that assertion, because as you said, the sentencing decision was 600 and some pages, and I think that admission was maybe the last reason for which she was convicted. You cannot convict a person on the basis of an admission and make 632 pages.
No, here is the thing is problematic. Problematic is we are talking about a case that she tried to deprive orphans money. That money belongs to the orphan house, Zia Orphanage Trust. Now, her signature was not inside the bank account. Her name was not even inside the bank account. But she's
and they were trying to cover this lack of signature. With an admission.
Now, question is, if a country's judicial where a judge's decision can be mastered or altered, does the court has any legitimacy in the eyes of the world or in the eyes of a country that we can say that there is a law?
There is an appeal. So this is the recourse that the defendants have after they lost the trial. And I guess that they have also the possibility, if they lose in appeal, to go to the Supreme Court, which, like here, is the court of losers, we say,
yep,
because they lost all the previous trials. So maybe that tribunal, that first court, may be considered illegitimate. However, let's see what happens in the appeal. Let's hope that it won't happen like in the trial court, and that the appeal will be accepted, in order for her to have a chance to participate in this year's election. So you can consider trial court illegitimate in the measure that you don't like the verdict. However, you have the possibility of appeal, and the appeal is pending. So let's see what happens in the appeal to see what happens with the system of justice in Bangladesh.
I'll tell both of you, I'll share the condition of the judicial system in Bangladesh. A couple of months ago, Hasina Sheikh was in America. She sent 4 or 5 of her armed cadre to the house of a Chief Justice, Surendra Kumar Sinha, who happens to be impartial judge, who wanted to make a landmark decision which goes against Hasina Sheikh. So those 5 or 6 people went to the residence of the Chief Justice, put a gun into his head and says, "You are going on a leave, sign that paper." Judge says, "I'm not gonna sign it." They force him. He happens to be Hindus, cuts the crap out of him. He says, "If you don't sign that paper, we're gonna take you out, or we're gonna kill your family member, or whatever." Do you know what they did? They forced him to put the signature, admitting, "I'm sick, I'm asking for 30 days leave." They take that paper out. He didn't write that paper. They put that paper in front of him to sign. Next day, he had that opportunity to speak to the journalist, who says, "I'm not sick, I didn't ask for leave. The paper was given to me, I just signed it." Okay. Finally, what happened? In front of a gun, he has to leave the country. This is the condition of the Chief Justice. If these things can happen with the Chief Justice of a country, what do you expect from this country's judicial?
No, it's very clear. The judge in this case obviously would have no control over the trial themselves because they would face the same
same consequences. Same consequences. All the judges, all the police officers, they're saying, I cannot make a right decision. If I make a right decision, I'm going to lose my job. I may not stay alive. So what they do? They just follow what Hasina Sheikh is saying.
Good.
So that's the way they're running the country. That's the way. Another thing I'll share. They accused Begum Khaleda Zia of less than $300,000. Less than $300,000. Guess what? Her son, under Sheikh Hasina's son, Hasina Sheikh's son's leadership, Bangladesh Central Bank almost lost $1 billion, and there is no single investigation. There is no case. There is no incident. 7 or 8 national banks lost their principal amount, principal investment inside the bank. There is no accountability. There is no single case. And her son was directly involved. I'm talking about the son of the illegal Prime Minister Hasina Sheikh.
Then maybe this is a signal that Bangladesh is leaning toward dictatorship, because usually in this kind of regimes, you are trying to divert the attention from the issues created by the presence in power, by pointing the finger and by sending to jail, making a scapegoat only out of the opposition members. So this was the way in an electoral year, just to get rid and divert the attention from these issues, huge economic losses and financial losses that might make her lose the elections, and put all the problems on the blame, the problems on the shoulders of
opposition leader and political party.
Exactly.
The way I describe what happened to the Chief Justice of a country, the way I describe the way people are getting killed, kidnapped on the street. So it means there is no law in the country. What Mr. Florescu was saying, Hasina Sheikh's word is the law of that land. In this type of scenario, can someone make a claim that no one is above the law?
You're a Bengali man. You can make the claim. You tell us.
Who can make the claim that no one is above the law when this thing is happening?
As you presented the facts, and we take it as because we have no contrary evidence. From this perspective, it seems that the things are, as you said, that there is no system of law ensuring the protection of fundamental rights and liberties. The system of justice is very complex. We don't have all the facts involved, but by these facts presented by you, it seems that the situation is so.
Mr. Korngold, we are end of our time. The situation in Bangladesh, I think you and me, we did a couple of talk shows on Bangladesh. Every single day, things are getting worse, worse than worse. This is the condition. 180 million people are living under the regime of Hasina Sheikh. At this time, you know, you are doing lots of political asylum case from Bangladesh. Lots of people are coming here. They're getting help from you. What's your perception at this time, the way people are running away from the country, how they can protect themselves even when they're going outside the country? They're trying to get these people back because immigration in this country is going harsher and harsher.
Well, there's no doubt that the way that Sheikh Hasina is running the country is not democratic. She's running it like a dictatorship, and there's no doubt that she's trying to hide behind a fake democracy. There's no doubt about it.
I wouldn't call it a government. The way she threatened the judge, isn't it look like some sort of mafia rule? Mafias goes behind the judge that you make the decision, otherwise I will shoot you.
It's very clear. The judges, the exile of the Chief Justice is by definition the hallmark of an illegitimate government. One of the ways that the United States is set up from the 1700s is that the Justice Department is separated from the other branches of government insofar as that they're not elected, they're appointed, and once appointed, are appointed for life. They cannot be removed except for the rare case we've never had. We've had 3 impeachments over the last 300 years that I'm aware of, never on the Supreme Court. They were all federal judges and they all involved corruption, bribe taking. It is otherwise impossible to remove a sitting justice except for specific cause related to their judicial duties. So clearly, because the Chief Justice was exiled, forced to leave the country, that by definition deprives the country of the ability to claim its legitimate democracy. You cannot have the judicial system subject to the whims of anybody. Even the fact that he signed a paper, but that doesn't ultimately lead to exile. Exile, by definition, is the hallmark of a corrupt system. And I just would point out that the reason why we can tell that Sheikh Hasina is hiding behind a democracy, but not actually running a democratic nation, is because she had him exiled instead of killed. Had she had him executed, okay, clearly would be no cause.
No cause.
All he did was rule in a manner that was unhelpful to her regime. That was it.
That's it. There's nothing else.
He's the judge. That's his job. He has every right to rule in any manner, shape, or form that he sees fit. That's what a judge does. They don't have to cater to the president. As you see here in the United States, several judges have overruled Trump.
Yep.
In many issues, including DACA, including his ban on
Muslim
immigrants from Muslim countries. The judges, without hesitation, overruled him. And that's the hallmark of a legitimate judicial system. The fact that he was exiled for doing nothing more than ruling in a manner which she found was improper clearly shows that this is not a legitimate government.
Mr. Octavian Florescu, thank you so much. We are out of our time. And obviously, I'd like to do another 3 or 4 shows with you and Mr. Korngold. This is really a good show. And in the future, we're going to invite you. And in the future, we're going to meet again. Thank you very much.
Thank you very much, sir.
Mr. Korngold, thank you very much.
Pleasure.
We'll meet again. Audience, একটা সভ্য দেশে বসে আজকের আমি 2 জন অ্যাটর্নির সাথে কথা বলছি, যাদের একজন ছিল গভর্নমেন্টের প্রসিকিউটর আর একজন ছিল ডিপ্লোম্যাট। এদের 2 জনের মতের উপরে আমি একটা সাবজেক্টে আমি উপনীত। সে সাবজেক্টটা হচ্ছে আমাদের দেশে আইন বলতে বা বিচার বিভাগ বলতে আর কিছু নেই। এক কথা বলতে গেলে আমি খুব দুঃখ নিয়ে প্রায় ইদানিং বলে থাকি যে আমাদের দেশ কোথায়? আমাদের দেশ আছে? Today, after having this conversation with 2 legitimate attorneys in the US, this is my conclusion. In Bangladesh, no one can claim, nobody have the right to say that no one is above the law. One of the attorney named Mr. Florescu, he was saying, Hasina's word is the law. Means, whatever she want, whatever way she pick, if that is the law of a country, then our country is not existing. That's not the way a sovereign country runs. As a matter of fact, I don't know in our country that free and fair election will take place. If that free and fair election take place and another government come, Hasina Sheikh should be held accountable to do the complete destruction of country's judicial system. There's a lot of other issues. I'm not going to talk about other issues, but only one crime itself that she destroyed our country's entire judicial system. The way she removed the Chief Justice, the way she was controlling every judges, including that so-called stray dog, State's Attorney General. Well, that's our show. I'll see you next time. My name is Jacob Milton. Stay well.
I have a dream that one day this nation will rise up and live out the true meaning of its creed. We hold these truths to be self-evident that all men are created equal. I have a dream.
And so, my fellow Americans, ask not what your country can do for you, ask what you can do for your country.
That will reinforce humanity's belief in justice, strengthen its confidence in the nobility of the human soul, and sustain all our hopes for a closeless life for all. All this we owe both to ourselves and to the peoples of the world, who are so well represented here today.
And once I was told about it, and having known the earlier background that the Pakistanis were out to kill our people, the civilian population and the Bengali army personnel, we had no other way but to take up arms and fight our way out. As a last resort, I wanted to tell the world what was happening, and I went up the air in the evening and I made the declaration. Having heard me over the radio, the other regiments of East Bengal Regiment and the East Pakistan Rifle and the police force also, they revolted.
Sovereign state of Bangladesh do hereby proclaim the independence of Bangladesh. I therefore appeal to the governments of all the democratic countries of the world, especially the big world powers and the neighboring countries, and to take effective steps to stop immediately the awful genocide that is being carried on by the army of occupation from Pakistan. To dub us the legally elected representatives of the majority of the people as secessionists is a cruel joke and contradiction in terms which should befool none. The guiding principle of a new state will be, first, neutrality, second, peace, and third, friendship to all and enmity to none. May Allah help us.
Arroyo Hokapat, Arroyo Hokapat, Negel Correlo